Good afternoon. Thank you to everyone for joining us for this CLE. Today we're going to be talking about sanctions under amended Rule 37 and specifically some of the changes that we've seen with respect to sanctions law between the existing Rule 37 before the December 2015 amendments and the new rule, as we like to call it. This CLE is sponsored by the Seventh Circuit Pilot Program on Electronic Discovery. My name is Christine Payne. I am a partner at Kirkland & Ellis in Chicago. I'm a litigator and I focus on complex civil discovery, but a key area of my practice is e-discovery strategy and advising clients with respect to the types of things they can be doing proactively before a case starts to get ready for e-discovery, and then also, focusing on advocacy and strategy once you do get into a matter. I'd like to thank Kirkland & Ellis in particular for underwriting the costs of this webinar. We're very excited to be talking with everyone today and with our esteemed panel regarding Rule 37. If you're not familiar with the Seventh Circuit Pilot Program, I really encourage you to go to the website that's listed at the bottom of this slide here. It's discoverypilot.com. The Seventh Circuit is, been in existence a little under a decade. While it kind of was initiated as a way in which we could explore ways to streamline and make discovery easier and better for parties and courts, it's really turned into a group that is effectively a thought leader within the e-discovery community, and there's lots of good resources for you available there. In terms of the program that we're going to have today, you'll see in your WebEx viewer that you may submit questions during the course of the session. You can type them right into the QA box and submit them. This court has been credited for 1 hour of CLE credit in both Indiana and Illinois. If you are looking to receive CLE credit, those certificates will be emailed to registered participants about 4 weeks after the program. You do, however, need to continue to participate through the program. The WebEx is kind of tracking to make sure that everybody continues to pay attention, and there will be questions posed to you during the course of the presentation that you can then answer, and we'll actually be able to see kind of the results of the polling for the whole group together. By way of introduction for our panelists today, we are honored to have 2 magistrate judges who think and live and breathe e-discovery issues when it's presented before their courts. Judge Baker, would you like to introduce yourself first?
Greetings. My name is Tim Baker. I'm a magistrate judge in the Southern District of Indiana. I sit in Indianapolis. It's certainly my pleasure to be with you today. I look forward to discussing ESI issues with you.
And Judge Johnston, how about you?
Hello, this is Judge Ian Johnston. I'm a magistrate judge in the United States District Court for the Northern District of Illinois, Western Division, located in Rockford, Illinois. I look forward to talking about amended Rule 37E this afternoon.
Nick?
Hi, my name is Nick Kalon. I'm a partner at Riley Safer Homes in Kinsella in Chicago, and we've had several cases involving these issues, so we're looking forward to discussing amended Rule 37 today.
All right, and finally, Jeff?
Jeff Salling, e-Discovery Counsel and Director of Business Development for Complete Discovery Source, and also the e-Discovery Professor at John Marshall Law School. And a big thanks to Christine for moderating for us today.
Just a very quick note, but an important one, and a disclaimer here. The thoughts and opinions that you're going to hear discussed today are those of the panelists alone, not to be associated with any of the courts or the law firms or clients that may be associated with me or with any of the panelists here. For today's agenda and the things that we're going to be talking about with the panel, we're going to take a look at prior Rule 37, how it existed before the amendments took effect in December 2015, and what it changed to. You know, the intent of the rule was really to even out a landscape of sanctions being imposed across the country that was very uneven, where, you know, in one court you might see big sanctions applied for conduct that in another court was either no sanctions or not even discussed. And so we'll look at kind of the changes that were implemented there to address that issue. We'll take a look at some recent cases that have come out since the amendments. And then we'll also talk about some recommended practices that folks can be thinking about as they help their clients comply with Rule 37 and, you know, approach the court as advocates on this topic. And with that, I'll turn it over to Judge Johnston for a discussion of what Rule 37 was before December 2015.
Before December 1st, 2015, Rule 37E was substantially shorter. It also started with a basic presumption against imposing sanctions. And one of the differences you'll note between former Rule 37E and the amended Rule 37E is that the former rule actually used the word sanctions. In the current rule, the word sanctions is not contained in the rule. Again, under the former rule, it only applied to ESI, to electronically stored information. But it specifically related to the loss of information that was caused by routine, good faith operation of a system, which most of us understand the phenomena that was occurring for years before 2015, namely when an automatic deletion system occurred, either for emails was a common practice where every, say, 60 or 90 days, emails that were captured and stored on a system were deleted off the system. And so the rule addressed that. Similarly, you'd have systems for video recordings where video was electronically stored and it was, quote, recycled, close quote, every 30, 60, 90 days. And so the rule specifically addressed that phenomena. Three important words in the rule were right at the start. It says absent exceptional circumstances, and then it goes on after that. So one of the concerns that developed with former Rule 37E is, well, what does absent exceptional circumstances mean? So would a litigation hold letter from opposing counsel with the classic preserve everything provision, would that be an exceptional circumstances? Or would internal email complaints from an employee to a supervisor about harassment, would that be an exceptional circumstance that would require the preservation of the electronically stored information? So there was a lot of case law that developed regarding when those words kicked in so that the routine practice no longer provided that safe harbor. The rule left a lot to be desired because it was short, very limited to that phenomena. And it seems like former Rule 37E was a classic example of the law just not being able to keep up with the pace of technology and societal changes. So that was former Rule 37E.
All right, wonderful. And then moving on to what the revisions were in December 2015, you know, a lot of folks practicing in the area, the bar judiciary got together. There was a committee that proposed certain revisions, and then those revisions went into effect. We have now a little bit more than a year and a half of jurisprudence on it. So what were the changes that were made?
Well, you have with the slide in front of you, Rule 37E as amended December 1st, 2015. I still catch myself calling it new Rule 37E, but it's almost 2 years at this point. It's a much more developed rule. I think the jargon of today is it's more fulsome. It's a very dense rule. There's a lot of information, a lot of requirements packed within that rule. Each phrase and word in the rule is important when you read it as a whole, and the rule establishes essentially a progressive screening or sifting process that allows the court to make the ultimate determination of, first, should there be sanctions, and second, if there should be sanctions, what those sanctions should be. And again, if you look at the full rule, the word sanctions isn't in there, which I think shows some intent that the idea behind the amendment is to make this more remedial, to cure the prejudice that's caused by the loss of the information. And if you look at Rule 37E as amended, the first paragraph sets up sort of the first step of the screening process that the court's going to go through to determine whether or not there's prejudice, or if you determine if there's prejudice or if there's intent to destroy the information. One of the key words is it talks about the loss of the ESI. It doesn't say destroy, it says loss. I lose my car keys on occasion. I have yet in my life destroyed my car keys. So there's the distinction between the loss of the evidence and the destruction of the evidence. And the destruction of the evidence is captured, that concept is captured under 37E2. So if you go through the first paragraph of Rule 37, the first step is to determine, well, is it ESI? And Judge Baker will talk about these in more detail as we move along. If it's not ESI, you don't even look at Rule 37E. And then you go through
one thing that's really, I apologize. I think one thing that's really important to me about Rule 37E is that we have a lot more of a framework, of a structure to be really thinking through a sanctions analysis. And in fact, I'm going to flip now to a chart that you've created related to how the new rule works. If you can see that on your screen, if you could explain that for a minute, that would be great.
Yeah, that's, I think I call it a flow chart I created that helped me visualize the process that was created by amended Rule 37E. And so it just asks you simple questions to help you and the court to determine, again, those ultimate decisions. Are sanctions appropriate? And if so, what those sanctions should be. And so it asks with those basic questions, is the information ESI? If it's not, well, no sanctions under Rule 37E. Was there a duty to preserve? That's based upon the common law. If there's no duty, again, doesn't apply. Was it relevant? The word relevance is not contained anywhere within Rule 37E, but it is in the advisory committee notes. And it's not surprising because Rule 26 is the overlay for all discovery, and Rule 26 contains the relevance requirement. There's no duty to produce irrelevant information, let alone preserve irrelevant information. So if it's not relevant, well, then there's not going to be any sanctions. And then did the party take reasonable steps to preserve? Was the loss of information unable to be restored or replaced through other discovery, for example, depositions, or if you can find it on a different drive or a legacy system, those types of things. And then you look at whether there was intent. And that goes to the sort of the destruction of the evidence, an actual intentional destruction of the ESI rather than the negligent loss, let's say, of the ESI. If you go through that process, you end up with the decision, was a party prejudiced by the loss of the ESI? I suppose some people have asked me about the flow chart, and they said, well, it focuses on intent under the rule. But the language of the advisory committee notes say, if there is intent, then prejudice is presumed. So I think that's the focus of the ESI, is that you look at the prejudice to the party when the ESI has been lost. And if there is that intent, prejudice is presumed. So how has a party been harmed by the loss of the ESI? And that's what that flow chart helps you work your way through, that decisional, the analytical process that you called the calculus in determining whether sanctions should be imposed.
You know, from a private practitioner's standpoint, what I like about flow charts like this is that it shows there's lots of areas for strategy here. If you have a client who has been accused of spoliation or you are making an accusation of spoliation, obviously there's lots of portions to this new rule as illustrated in the flow chart where you really have kind of room for argument and advocacy. Judge Baker, for new Rule 37, what are your key takeaways?
Well, it's definitely a different approach to managing sanctions issues and frankly, managing the case as a whole. Lawyers and parties were so concerned previously about the possible imposition of sanctions. It really created a lot of cost, a lot of activity involving electronic discovery that I think under the new rule doesn't happen anymore. I think there's a recognition that with the new rule that electronic discovery is different than classic paper discovery. It's different in the volume of case, the volume of discovery that's out there. It's different in the type of information that's on the discovery. It's different on the way that we preserve and delete this information. And so there's really been a sea shift in the way that lawyers and certainly the court is handling this, and it begins, I think, before the parties ever even come into court. And if done appropriately, if the rules are followed and people give proper consideration to electronic discovery and how to manage it, I think many of these problems can be avoided. And so that's what I like to see. I like to see lawyers who recognize that ESI is different, that the parties recognize ESI is different, and they deal with these issues up front and avoid all the problems that unfortunately sometimes turn into horror stories for litigants and their lawyers.
What are some key takeaways that folks need to know about the new rule?
Well, in terms of an approach to the cases, now I go around and I do talk with different judges across the country in terms of some of the new rules, and so I see how they do things in different districts. And one thing you'll know if you practice throughout the country at all is different federal districts. There's 94 of them. They're going to do things differently. But I think the takeaway should be to embrace active case management by the lawyers and by the judges. You know, if you go back and you kind of reflect a little bit upon the amendments back in 2015 and look at where that got us today, Justice Roberts, in his year-end report, which he does every year, reflected upon these amendments himself and said, you know, in light of these amendments, we're encouraging judges to be engaged early in active case management. And so I think the takeaway is expect judges to be actively involved. There, again, will be some variances in different districts. I can tell you in this district, in the Southern District of Indiana, we are very involved. Some lawyers might call it micromanaging. I like to call it active case management. But any case that's not going to be exempted under Rule 16, like for example, a Social Security case or a foreclosure case, cases that aren't exempted. The routine type cases that that are the bread and butter of federal court: the employment discrimination cases, the diversity cases involving negligence, the civil rights cases. All those cases that we typically see, they're all going to be subject to a new and hopefully improved style of active case management. And I'll talk on that just a little bit, because while it's the court's role to do so, it's also the party's role to be involved in active case management, and the attorney's role. Before you come into federal court for your Rule 16 conference, there is an obligation imposed under the Rule 26F, to have a conference among the lawyers to prepare. And one of the first things you should be asking yourselves is this a case that involves electronic discovery, or at least a substantial amount of electronic discovery? Because there's a lot of cases that really don't. I see plenty of cases where someone slips and falls in someone's business, or it's some other type of case that's not going to be particularly complex, and it's not going to be an ESI type case. And if so, then be aware of that right up front. It's going to affect the way you do your discovery, and perhaps the way the case is managed by the court. But if it is a case involving electronic discovery, the lawyers need to have that conversation at the Rule 26F conference. And they need to do a few things. And the takeaways would be, identify the people within my client. And a lot of times this will go to the defendant who's being sued, but it can also apply to individual plaintiffs. Identify people who are the most knowledgeable about computer systems. And the lawyers should be meeting with those people in advance of the Rule 26F conferences to make sure that they understand what they're dealing with here. How can you possibly enter into a Rule 16 case management order where you talk about what's going to be preserved and what holds are going to be placed on things if you don't even understand your client's system? And I know we've got a representative on the phone from a kind of a litigation perspective and a defense perspective. I'd be really interested in knowing what kind of conversations go on the, we'll call it the defense side or the employer side, at least the corporation side, in terms of identifying the systems and what kind of communications occur with the lawyers in terms of preparation for these Rule 16 conferences and Rule 26F conferences.
Judge Baker, I think that's an excellent question. From the perspective of someone who typically represents defendants, or at least corporations in litigation, I can tell you that having kind of a continual conversation with your client and starting that conversation as early in the process as possible is absolutely key. For a lot of our clients who are repeat players in litigation, we like to work with them well before a case even exists to make sure that they have strong information governance policies in place, that they themselves know how their systems work, and that we're familiar with it also. And I think, more than just knowing, how their systems work and that they have an email and that they have a shared drive or other data housing locations, is also just knowing kind of in practice who are the people at your client that are making decisions. Are there paralegals who are responsible for doing custodian interviews? Is there an information data security person who actually goes to retrieve laptops when employees are terminated? Having those types of relationships and being able to discuss these things with those people can head off worlds of problems, because it means that if someone starts to feel like there's something a little off, they're going to raise their hand a lot sooner and with more confidence than if you didn't have that conversation, if you didn't have those relationships. We probably have conversations with clients related to, lost data, lost laptops on a much more frequent basis than either they or I or the courts would prefer. And we really just want to make sure that, we're doing everything we can to be proactive on that front. Also, if you know the client's data systems, if you have these discussions early on in the case, you can use that 26F conference as an opportunity to address, certain things that you don't want to see included. It's a lot easier at the beginning of the case to get everyone to agree that system files or cookies or internet caches need not be collected or produced because it's completely irrelevant. But if you don't kind of think through those types of things that should be excluded at the beginning of the case, and then you get halfway in and there's some sort of hiccup or question, then kind of the tone is all of a sudden much more adversarial, and you have a lot of explaining to do, and it's not as easy as if you would have just thought it through, worked with the client at the beginning, and been able to draft around it in a discovery agreement that is then blessed by the court. Specifically with respect to Rule 37E analysis, or an allegation that there's spoliation or a situation where the client suspects something has been potentially lost, what we do at Kirkland to address those types of situations is called a gap analysis, or that's how we think of it. And basically what we go in and we do is we take a look at what we think existed at one point and what exists now. We look at kind of how that happened, what changed, who was involved, what data systems were there, do we need an expert to help us explain the change? And then we really do, I've never had the benefit of Judge Johnson's flowchart before. I'll use it now, but we go through each one of those steps and really look for advocacy points where we can make it absolutely clear that to the extent there was a data loss, and perhaps there wasn't, that it wasn't an intentional deletion that would put us kind of into what I think is the bad bucket of conduct. But the other thing I'll say is if you have this relationship with your client, if you have an ongoing discussion, a lot of times you can get in and really encourage people to look around absolutely everywhere. And perhaps the data isn't even lost. I had one example of a client who was concerned about a loss of email. And as soon as we got in there, we started really asking about whether email had been backed up. We started asking about backup tapes and archives. And it turns out that for another case, there had been a snapshot taken of a particular email data set, and that included the data that they were afraid was missing. So there was no problem at all, but it just required a little bit of sleuthing and a little bit of creative thinking to think about where it could be. And so in that situation, we went from being fearful about a spoliation allegation to being able to review and produce the data like there was never any problem. I don't know. Nick, what do you think? From your perspective, do you think about these things in talking with clients?
Certainly, and I think that your description of and your explanation of wanting to have both the knowledge of how your client systems operate and having that trust relationship built where you can ask questions and you can find out other things that the client themselves may not necessarily know are important. And so kind of building on the last point you made, which is the idea of snapshots, one of the things that I've seen is that when you're confronted with a spoliation issue, and we'll talk about this a little bit in the context of some of the hypos, sometimes you may be able to find that data elsewhere. And so even if you've lost the emails or the client has lost the emails for a particular custodian or employee, those emails may exist because they were sent from other people or they were received by other people. And there may be, as you just mentioned, Christine, snapshots or backups of that email, of that custodian's data or the company's other data sources. And so really having a good understanding and a good relationship with the people at the client who know those things is invaluable when you're dealing with Rule 37 issues. And I think the other reason it's really important is because when you have these discussions with the court, and it's never, hopefully, you get blindsided with a Rule 37 motion. In most cases, you'll see the train coming. And when you see it coming, or even hopefully when you can anticipate it, and you can go and talk to the court about what's been done to preserve data, what's been done to collect data, and if there's an issue, you get in front of it, you disclose it to the court, you disclose it to opposing counsel, and hopefully when you do that, you come prepared with action items that you and the client are going to take to try and fix it. here's the issue that we've discovered, and here's what we're doing to address the issue. We're going to search these other email accounts, we're going to search these other data sources, etc. When you do that, you establish not only credibility with the judge and the, frankly, opposing counsel as well, but mainly the court for when the ultimate Rule 37 determination is made. And I think you're also building a record to offset any finding of bad faith, because everybody acknowledges that there will be issues from time to time in discovery, and when you are able to get in front of those issues and you have a record of not only being forthright in what you and your client have been doing, but also here are all of the steps that have been taken to try and preserve and collect data in this case, I think it really helps you when you're ultimately trying to fight off a Rule 37 motion. Jeff, what's your perspective on this stuff?
Well, for the last 2 years since the rules changed, the preservation has gotten a lot more attention. So clients are a lot more knowledgeable that they need to be on top of it, but that doesn't always mean that they know exactly what they need to do or what they need to be concerned with. For me, it depends what side of the V I'm on. So if I'm on the plaintiff side, a lot of what we do is analyze the data to make sure that they received everything from the defendant. So we're going to look at date ranges, we're going to look at custodians, we're going to look at quantities, and we're going to say, all right, for this particular custodian, we don't have anything for a specific year. Why is that? Did they go work somewhere else? Were they out on some type of leave? Or did we not get that data? Was there a preservation issue? And then we can help them go back to the other side and say, we don't have all the data we expected. How come? And really just kind of help paint that picture, because a lot of what we're trying to do is help them put the picture together of the data that they're receiving. And a lot of times it might have just been a mistake. It hasn't come yet. But sometimes it's because that data wasn't turned over because it was lost, and then we can help them figure out what to do from that point. When we're on the other side, when we're working with the defendant, it's really an understanding of, as everyone else has mentioned, where the data is at, do we still have the data? And being a teacher, I'll tell a quick story, because as Christine mentioned, these conversations are really frequent. So 2 weeks ago, when I was with one of my law firm clients, what had happened was they collected 9 terabytes for a matter. They've been working on it for the last 2 years. They had been whittling it down with their current vendor, and they had somehow whittled that 9 terabytes down to under 5,000 documents. And as they put together their case, they realized they needed to see a lot more of the data. And what had happened was, about 6 months prior to myself becoming involved in this case, the law firm had decided, well, we've whittled it down, we don't need to know more, and had instructed their vendor just delete everything else. So when they find out we need to go back, we had culled it far too much, the 9 terabytes was gone. The vendor was instructed to delete everything, and that was a great example of people not understanding the ramifications of the decisions they make. As we know, who are in this space a lot, you're always going to need more data. You're always going to go back. Your theories of the case are going to change. The date ranges are going to change. The custodians are going to change. So to delete anything permanently is such a risky thing to do in an ongoing litigation. And in this case, luckily, the corporate client was smart enough that they had retained all of the hard copy or the hard documents. They had desktops, they had laptops, they had backup disks, but none of it had been processed. So we had to recollect 9 terabytes. We had to reprocess 9 terabytes. It was a really expensive mistake for someone to make, but that happens a lot when we come to, especially this issue of preservation. And the last thing I wanted to point out was, with Nick's last point, was once you have put together the picture, and we'll learn a little bit more in some of the cases that we're going to talk about today, how important it is to disclose what has happened to the court and to opposing counsel, because when you don't do that and when you try to hide things and then it comes out, you're in a lot worse position with the court.
All right, and with that, let's go into some of the hypotheticals that we're seeing come out of recent case law. Nick, do you want to discuss case hypo number 1?
Certainly. So let's imagine a hypo that I'm sure many of the people listening to this broadcast will have been involved with, where you've got an employment dispute, and in this particular hypo, the employee is assigned to a new position that she believes is retaliation for reporting alleged harassment. She retains counsel. The attorney sends the employer defendant a preservation letter, and then after that, the employee leaves the company. 90 days after she leaves the company, pursuant to the defendant's internal policies, they delete her emails. And then to add kind of another fact to it, let's further imagine that another employee who has knowledge of the facts of the dispute also leaves the company, and their emails are also deleted 90 days later pursuant to this internal policy. The plaintiff is seeking the emails in order to show that her assignment to this new position, the reasons for that assignment, are pretextual. And so she's hoping that in her emails and this other employee's emails, she'll uncover evidence to show that, in fact, it was retaliation for her reporting the harassment. Because the emails have been deleted, her attorney files a motion for sanctions based upon the destruction of emails. What do we think would happen in that case under amended Rule 37E? Are sanctions warranted? Now, because we're recording this now, and obviously people will be listening to it later, we can't see how you'll vote on this, but we'll pause and give you an opportunity to vote, and then I'll come back and tell you what actually happened. So the ruling in the case was that sanctions were not warranted, and the court walked through amended Rule 37E and the different iterative steps that are required under the rule, and some of the key pieces of the ruling are summarized in this slide. In particular, the court reasoned that the plaintiff was not prejudiced by the loss of her emails because she obviously had firsthand knowledge about what was in those emails and could testify about them. And to go back to a point that we were discussing earlier, the court went on to find that there wasn't necessarily prejudiced by the loss of the other employees' emails because the defendant had gone out and searched for and obtained emails received by or sent by other employees regarding that employee whose emails had been lost. There was no evidence to suggest that the defendant had destroyed the emails with the intent to deprive the plaintiff of the content of the emails. And so really what it came down to was there a showing of prejudice? And the court determined that in the end, regardless of which party bore the burden of persuasion on that issue, the court just had very little evidence regarding the particular nature of the missing ESI, and that it would be purely speculative to determine that it would have benefited the plaintiff under those circumstances. And that decision was in the Snyder v. Danfoss case in the Northern District of Illinois. And now we have on our panel the judge who actually issued that decision, Judge Johnston. And so let me turn it over, Christine, to you and the judge to talk about that ruling and some of the issues that it raises.
Yeah, I think this is an interesting opinion for me. For those folks who learn better through reading opinions, or if you ever just need a refresher on what are the issues surrounding the amendment to Rule 37E and how does the new rule work, you can tell this is an opinion when you read it. You can tell it was written by someone who likes a good flowchart and kind of lays out all of the different areas for potential advocacy that we see in this type of an analysis. One thing that the Snyder opinion really does is it emphasizes that in order to evaluate prejudice, as you mentioned, Nick, that the court must have some evidence regarding the particular nature of the ESI. But how can a party alleging spoliation provide that proof if the data is gone? If we don't know, how can we say what it is? So Judge Baker and Judge Johnston, if you'd like to talk about that briefly.
I'd like to hear what Judge Baker has to say I want to know if he thinks I got it right.
You always get them right.
Because I learned from you.
Yeah, that's very, very funny. It's interesting, this case, and it's a great decision, truly. But just I'm going to make two other observations regarding this factual scenario, and then I think it's more appropriate to let Judge Johnson kind of go into anything else he wants to say about his reasoning. But when you have disputes on ESI, or any disputes for that matter, what strikes me about this pattern, this factual pattern, is this motion seems way premature. The fact that this would have prompted a sanctions motion, at least in this district, and a lot of districts have this, but in our district we have Local Rule 37-1, which says that before you ever file a sanctions motion, you need to try to reach the magistrate judge to see if the dispute can be resolved. And it may be that that was attempted in this case, or it simply wasn't resolvable short of a motion, although based on the fact pattern, I would think it should be resolvable because the motion, again, seems premature. Local Rule 37-1 is designed to head off motions to compel and motions for sanctions. Those types of motions, motions to compel, motions for sanctions, tend to bring the entire case to a grinding halt, and certainly causes a lot of concern by lawyers and their clients, and also by the court. So I just wanted to emphasize at this point that before anybody ever files a motion like that, check your local rules, and particularly in this district, you'd need to contact the magistrate judge to try to resolve that if at all possible. The second observation I wanted to make about this fact pattern relates to the employer's policy here of 90 days. Things are deleted after 90 days. One kind of important thing to keep in mind is it's not the court's role to second guess a company's internal policies for preservation. The question is, was the policy followed? So they might have, in this case, a policy for 90 days. It could be a policy for 30 days or a week. That's not the issue. The issue is simply, among other factors, was the policy followed. So although 90 days is pretty short, that really shouldn't factor into any determination of whether sanctions are appropriate. Judge Johnson?
And I'll go back to the points that counsel had made earlier on trying to get out in front of these issues. The parties did preview the possible issue. I think they saw it coming, and certainly the employer saw it coming. And I can only feel for defense counsel when they get that call from clients saying, you know, well, the emails are gone, we deleted them. It's never a good feeling when you're counsel and you learn that. But they tried to get out in front of it, and the opinion lays out all the ways that they tried to mitigate the harm and the damage caused by the deletion by capturing the other employees' emails, producing those. I want to say there were several gigabytes of emails, that 22 gigabytes of data that they sorted through after the emails were deleted to see if they could salvage the information. So getting out in front of it is key. There's an old phrase, if you mess up, fess up, and they did that. If there's a mistake, admit to the mistake. Don't double down on the mistake or triple down on the mistake. They saw the mistake and they tried to remedy the situation. So that to echo counsel's point, that goes a long way in the process. To Judge Baker's point about the motion being premature, we don't have a specific rule where they call the magistrate judge's chambers about discovery issues, but we do have a local rule, and it's now incorporated under Federal Civil Procedure 37, that they need to at least engage in discussion. They did that. There were lots of letters and emails back and forth about the dispute, and they just couldn't reach an agreement, and the plaintiff's counsel didn't think that the despite what defendants had done, was sufficient, so they brought the issue on a motion. Judge Baker's point is a good one, that we don't want discovery disputes to grind a case to a halt. So I generally rule on all discovery disputes when they're brought before me. I don't take briefing on it. If somebody wants to file a response brief, I'll read it. But unless it's a sanctions motion like this or a privilege issue, I'll generally rule that day, that morning, so that things don't grind to a halt. This one, I can't remember what the turnaround time was, but the case was allowed to proceed, and this came at the very tail end of discovery, so it didn't hold up things so much. And the main point that I was making in this decision is I just didn't see any harm to the plaintiff, especially with the loss of her emails, because she could testify to whatever she wants. I hope litigants and witnesses testify truthfully and honestly, but she could testify to what she put in the email and what somebody sent to her, and the defendant could cross on it. So I didn't see any harm there. As to the ultimate issue that all these cases boil down to is you're trying to figure out something out of nothing, because the information is gone. And so how do you determine the harm to a party? The defendants, obviously, or the party that lost the information, is going to downplay the importance, and the party that sought the information is going to play it up. And so you'll look to other avenues to try to figure out what type of information would have been caught there. Is there a witness who could testify or did testify in deposition that these types of matters were frequently discussed through email communications with the employees and the employers and the supervisors? If that's in there, that obviously informs the decision. So there's got to be something to work with, otherwise it's pure speculation for both, and then you got to go through a very difficult weighing analysis to determine the likelihood that that information would be helpful for one side or the other.
I thought that was a really interesting point in the opinion, thinking through what could be in these emails. Obviously, we don't have the emails, we don't know, but the complaining party here, the party alleging spoliation, was the plaintiff. And so either the emails are helpful to her case, in which case she could testify and say, what had been communicated. And of course, defendants couldn't impeach her with anything because they themselves deleted the emails. Or the emails, exist as they existed, were harmful to her case, in which case having them go away is better for her. So in this odd situation here, where given the particular allegations of the case, given the particular circumstances, figuring out how she could be prejudiced by the loss is a really unique analysis, because a lot of times just everyone is so guffawed by the fact that there has been a deletion, but that's not an automatic gotcha at this point. You really do have to be able to show some evidence of what was in there to allow for the prejudice analysis. All right, moving on.
I think that's an important point on the gotcha. That when you think about it, the whole process is designed to discover the truth, and when evidence is lost, destroyed, that process breaks down, and so there's that sort of visceral reaction. There's almost nothing more detrimental to the justice process than the loss or destruction of evidence. You have that initial reaction, but then you need to go to the next step of the analysis is, okay, so what? It's bad, but did you get hurt?
I think that's true. I think one of the quotes in the opinion is, from basketball courts everywhere, no harm, no foul. In this case, that's where we ended up.
Mm-hmm.
Taking a look at our second case, Jeff, would you like to run through our second hypo?
Absolutely. So it's really a simple fact pattern. It's a trademark case, and what happened was The defendants had a particular email address they had been emailing from, and then they changed it, and the plaintiffs accused them of altering their emails and saying that they had never changed their email addresses, it had always been the one, they just altered these emails when they had produced documents. For that reason, the defendants argued that sanctions were warranted under 37E, and the plaintiff said, well, since you have the documents, both with each email, you have everything, and sanctions aren't warranted. So what does the group think? Are sanctions warranted in this situation?
And I want to drill down just a little bit here, because this is when you read this opinion, it's confusing. The changing of the emails, I mean, what does that mean? Really, literally, when the party receiving the discovery looked at the documents that had been produced, there were some email addresses, some emails that had been sent from a specific domain, and then there appeared to be duplicates of that exact same email sent from the same person, but with a different domain name. And in this case, the domain names really mattered because it had to do with when one party became aware of certain operations of that domain name. Jeff, did I get that right?
Yes, absolutely.
All right, and then again, since we're recording this, we can't see the audience's reaction, but I think the big question is, in this situation, where obviously the receiving party is skeptical and they think that the domain names have been deliberately altered to help the substantive facts of the case, and the producing party is saying, no way, this is some sort of act of electronic God here, are sanctions warranted?
So in this case, sanctions were warranted. This is one of the first cases, once the new rules came down in December of 2015, that came out citing the new rules, and the court held that the plaintiff had intentionally altered the emails, and that really cast doubt, a lot of doubt on the authenticity of the originals then. So even if the originals were obtained, there still was doubt to whether they had everything, and the court decided that sanctions were necessary here. And per many cases, this really isn't the end of the story, so I want to turn it over to the judges to discuss what happened next on this matter.
Well, when you read the Cat 3 decision, you look at it and you think, wow, this is one of those terrible, terrible cases where a party did something awful and they changed as noted, the domain names, and the timing of the domain names was critical. And there's documents out there that are what they called they're emails just underneath, like a second level, with all of the other domain names. And after the decision was published, the plaintiff was able to track down the person who did the migration of the emails, and that person submitted an affidavit explaining that during the migration process, it did in fact cause those domain names to be changed. It wasn't intentional. It was done pursuant to the process, the electronic migration process. And at the end of this case, there was a stipulation to dismiss. It's dated April 6, 2016. I see a lot of stips to dismiss in my job. Rarely do I see a stip to dismiss that contains the following language, which is contained right here. It says, defendants acknowledge that neither plaintiffs nor any of their owners or agents engaged in any discovery misconduct or wrongdoing, and accordingly defendants hereby withdraw their motion for sanctions and all related claims of spoliation and or alteration of evidence against the plaintiffs. So what was presented to Judge Francis wasn't everything, and the plaintiff then went on to continue to research the issue, found the person involved in the migration who was able to say there wasn't intent here, was done by the process of migration.
So just to recap, because this is very confusing. So we have plaintiffs producing documents in support of their case. When they make that production, the defendants see this discrepancy in the domain names of the emails, and they make this allegation that the plaintiffs have actually deliberately altered the documents ahead of production to get kind of a substantive leg up in the case. All of a sudden, we find ourselves in this huge sanctions and spoliation firefight where the plaintiffs are trying to figure out how in the world they got there. You know, they say we didn't alter anything. This had to do with a migration, but the court goes ahead and enters an opinion anyway, imposing sanctions. And then after that opinion is here, what is cited at the bottom of our slide. But what you're saying is that after that opinion, they did more digging, found an expert who could explain the migration discrepancy, and then finally at the end of the day, everyone agreed that no intentional alteration had happened?
Exactly.
Well, for my own personal blood pressure, I'm very, very glad I was not involved in that case. I think, we do get calls from clients on a regular basis who have a concern or want to talk through an issue about data that was potentially lost, or, could we come in and explore these types of things? The takeaway for me from Cat 3 is that when you're in, data evaluation mode, either because you are proactively putting into place an information governance policy, or because you're in litigation evaluating where ESI might reside, you need to be documenting like crazy. And you need to be absolutely fluent in the systems that you have, the data systems, and changes that are being made. Because otherwise, you're about to find yourself being accused of very serious misconduct without any ability to really articulate why you didn't do it. Something that's very interesting about Rule 37 and the new Rule 37 is that there's no burden of proof assigned to either the person accusing spoliation or the litigant being accused of losing data. And so in this situation, this is a perfect illustration where you can see that when the allegation is made, everyone's going to start slinging mud every which way to either defend themselves or to prove the point to get the sanctions here.
And that's a key point on burden of proof. I don't know what Judge Baker's view is on it, but when you get a really, really close case, one that you're struggling with as a judge, sometimes it boils down to which party has the burden of proof. And Rule 37 gives us no guidance, and in fact, the advisory committee notes say we leave it to the judge. Well, that's not really helpful for us, but it gives us more discretion in deciding a case.
Well, I'll hop in here. My view on that issue is similar to my view on all kind of discovery issues or any disputes when you find yourself in front of the judge, and that is you want to be the lawyer who seems to be the most reasonable person in the room. You want to be the person who appears to be the one who has tried the hardest to resolve the dispute. You want to be the lawyer who appears as though you have tried to address this proactively, if at all possible. Because these are difficult questions. The results, if there's a sanction, could be catastrophic for a lawyer and even for the party. It's nothing a judge wants to do. So you just the idea of dotting the I's, crossing the T's, doing everything you need to do, working with your client. You don't want to find yourself in this situation suddenly with a sanctions motion. It starts, as I had kind of mentioned earlier in this seminar, with that Rule 26F conference and talking with your people so you know what you've got, what's being preserved, what needs to be held, and things of that nature. So I really strongly agree with Judge Johnson in terms of the rule unfortunately doesn't give us complete guidance or any guidance on that particular issue of burden, but you want to be the one who is the most reasonable in the room because on a close case that can sure make a difference for you.
Moving into our final hypothetical, Jeff, would you like to address this one?
Yeah, absolutely. So this is a case where the defendant issued a litigation hold. They conducted trainings on it. They really did their due diligence on the front end to make sure that the data was preserved. But one bad actor within the defendant, a senior executive, deleted over 40% of his emails from his inbox and his deleted folders, despite knowing about the legal hold. And the company, discovering this information, the defendant responded promptly. They brought in a forensic expert to examine the emails, find out what could be recovered, and they were able to recover some of the emails, but not everything could be recovered. So in this situation, does everyone think sanctions should be warranted? And the court decided sanctions are warranted. Despite the fact that the corporation did issue a litigation hold, they still didn't preserve the data because of a bad actor within the organization, and they failed to take reasonable steps to preserve the data. And unfortunately, because the emails could not be restored or replaced, and it was done in bad faith with the intent to deprive the plaintiff of those emails, sanctions were warranted in this matter. And big sanctions were warranted. The defendant was sanctioned $3 million, and the bad actor was sanctioned $1 million for his role in deleting the emails.
It's quite an extreme case. I think for me it's a surprising case, given that the intent of these amendments really was to level out the landscape of extreme sanctions that we're seeing applied. And also just reading this opinion from a lawyer's point of view is kind of a sad experience, because in this case, in Plantronics, there was obviously deletion that occurred, and there was direct evidence regarding the intent of the deletion. Isn't that right, Jeff? Because the executive who was deleting emails actually said so in emails?
Yeah, he said so in emails, and I believe he also instructed some of his team members to delete their emails. So the intent to deprive argument was pretty easily made. I wanted to point out one more thing. In addition to the monetary sanction, there was also, the court imposed a permissive adverse inference instruction, as well as expressed a willingness to impose evidentiary sanctions if warranted as the case progressed to trial.
All right, so they got hit with not only a monetary fine, but also, kind of an adverse inference type fine. And those are hugely problematic because they take the substantive portions of the case and alter it, really. So if you had a great case, now all of a sudden you have a good case. If you had a good case, you have kind of a bad case. If you have a bad case, you have a terrible case. That type of change for the substance of a case because of a discovery issue is really hard. The other reason I think that this opinion is just personally sad is because, there was deletion and there was evidence of intent, but the general counsels in this office in this case also did a lot of things right. I don't know this person, but I can kind of imagine her getting out her legal pad and listing out all of the things that one could theoretically do to preserve, relevant data and documents. And then once the GC's office learned about this issue with the executive deleting emails, really responded in a very vigorous way. All right, so in conclusion, I'd like to just go through each of our panelists, and if you have, kind of your quick 30-second takeaway for what folks need to be thinking about when they're looking at the amended Rule 37E and trying to help their clients comply, what would that be? Judge Johnston, we'll start with you.
Well, like everything in life, if you can avoid the problem at the start, do that. And so, building on Judge Baker's point, when the case first comes in the door, address it with the court, and then when you had your 26F with opposing counsel before then, address it with them. on what ESI is out there, what steps are going to be made to preserve, address as many ESI issues as you can at that 26F. And if you have issues, raise it at the Rule 16 conference. And if you do unfortunately find yourself in a Rule 37 firefight, if you're the party asking for the information, explain how you were prejudiced, and if you're the party that lost the information, explain why the other side is not prejudiced.
All right, Judge Baker?
I echo Judge Johnson's thoughts and would just note that that the discussion between counsel and even with the court is an ongoing discussion. Just because you have a Rule 26F conference early in the case doesn't mean when trouble develops you can't continue to have those conferences and get the court involved prior to filing any motions. Sometimes just having that conversation with a judicial officer helps promote resolution or helps get additional documents and information turned over. And in the spirit of that, we've been talking about the amendments to to Federal Rule 37E in 2015, but it should also be noted that was not the only rule that was amended as part of those amendments that were submitted to Congress and approved. Rule 1, everybody's favorite rule because we all love the just, speedy, and inexpensive determination of every action, was also amended, and it was amended to indicate that not just the court, but the parties have an obligation to make sure that's happening in the cases. So the way you deal with ESI and the way you handle preservation and production of that is consistent with the revised Rule 1 also, which is that the parties have a stake in the outcome as well.
Nick, what would be your key takeaway?
So I think that as lawyers, we can't control everything that happens in litigation and in the ESI context and our clients' kind of procedures, but what we can control is our preparedness and our forthrightness with the court. And so I think that my key takeaways for the listeners would be as knowledgeable as you can about your client's ESI practices, and when you have issues, be proactive to not only disclose those, but when you do disclose those, come prepared with plans to address the issues so that you can blunt and hopefully negate any finding of bad faith on your client's part if you get to a Rule 37 firefight as the judge characterized it.
Jeff, what's the one thing you would like the audience to think about?
For me, it'd be making sure that you have the right people involved in the process and you get them involved in the process quickly. The last thing someone wants is to be brought in when the motion's in 15 minutes and to be expected to give a thorough explanation that someone can provide to the court. If I'm a senior partner on the case and I don't know a lot about e-discovery, then I need to find someone that does. And I don't think it should be assumed that the young attorney is the person who knows everything about it, because frankly that's not always the case. So it's finding the person within your firm or outside of your firm that can help you navigate these issues effectively.
All right, I want to thank everyone so much, thank our panelists, and thank Kelly Warner, who worked with us from the Seventh Circuit Pilot Program, for putting this together, and thank the audience for participating. We really enjoyed this discussion. If anyone has further questions, we do have that Q&A box. It is available on your WebEx viewer. Please let us know. These are dynamic and ongoing developing issues, and it's something we can look forward to talking more about in the coming years.